afternoon, ladies and gentlemen, and welcome to another edition of The Law and You. I want to go straight into our topic today. And I want to say without any reservation that an attorney at law has all right and coverage under the laws of Guyana and any law that we will find internationally to advise his or her client in terms of his best option. Now that is based on the competence of counsel. Now, an attorney at law is correct if the attorney advises a client to remain silent. To remain silent is a privilege and a coverage under the Constitution of Guyana. You have a right to not incriminate yourself in any matter. And a court of law will not fault you if you choose to remain silent. Now, let us begin by looking at Articles 139. Articles 139.3 gives a person who is a suspect and has been arrested by the police, gives a person a right to retain an attorney at law of his choice. Now, it also gives the person a right to communicate with that attorney at law of his or her choice. The communication between counsel and the client is, of course, covered under our Legal Practitioners Act and our Code of Conduct. And we have privilege, of course, and provision under the law to ensure that whatever communication is done or made between client and attorney is held confidentially. Now, there are a number of things that spins off of this, which touches very serious issues in relation to the rule of law. We have listened to a press release where a statement was prepared not in the presence of the person or the author, but the statement is prepared in the absence of the suspect and is presented to the suspect in the presence of counsel. And the suspect is asked to sign that statement. That statement, we have listened to our press release, was of course not signed, as counsel rightfully advised her client not to sign such statement. It is clear that a statement which is given must be free and voluntary. If a person, with all that we have listened, under the circumstances, is compelled to sign the statement, that in itself defeats the purpose, because any competent court who can rule that that statement being taken under such oppressive circumstances is not admissible. And it's there, and therefore there are umpteen case laws, there are a whole line of case laws which will inform the police that you cannot force a person to give a statement, because a person has a right under the law to not incriminate him or herself. These type of laws are not special to Guyana. These types of law has found great foundation in the international arena. And many of our countries of the world has catered and has made this type of provision where a person has a constitutional right against self-incrimination a very valid one. Now, to answer or not to answer a question is your choice. Now, you cannot be compelled to answer a question to the police. It is the responsibility of the police to do their investigation and to find evidence if they can, independently of your involvement. If you have decided that you will not cooperate with an investigation, then that can likely be to your detriment, or it can likely be to your support at a trial. It depends on the circumstances, and competent counsel weighing the circumstances must make the judgment call in the advice of his or her client. Now, you would understand clearly that this right is available not only in criminal proceedings, this right is also available in civil and administrative actions, and of course in other forms of investigations. The right to self-incrimination or against self-incrimination is bestowed on every person who has to give evidence. And of course, if the person chooses to remain silent and his statement is forced out of him, then it now moves into the realm of whether whatever he has said, whether that can be admissible by a court of law. Now, police doing investigations in relation to financial matters carries a different operations. And there are, of course, laws and provisions and procedures which can allow the investigator to move from his office and move to a court, a high court of law, and to have an order or a subpoena directing that the person relates or reveals certain records or financial information. So what has taken place today must not in any way mirror that our country is in a chaotic state and that our laws are in a chaotic state. Our laws are not in a chaotic state. The investigators, and that is why I've always advocated without any type of reservation, that if one is going to enforce the law, they must know the law. And they must seek advice. What we have heard from counsel is that prior to her visit on the 28th of October 2022, that she was informed that if you maintain a certain posture with your client, you will be arrested. While other lawyers might take it from a different angle, I wish to take it from this angle. Investigators would have had enough time to seek legal advice in relation to that issue. There is, of course, no fault on the part of the legal advisors in our system, because no such advice would have been given at all. So their action is inexcusable. And it is a direct, callous, and of course serious infringement on an attorney's right to advise his or her client. And it must be condemned. And that persons hiring attorneys must feel a sense of comfort that there is law which protects that communication. There is law which protects that advice. If you were advised and that advice was not sound, then of course there is law to even deal with that aspect. So this situation, which has brought again our country in a very embarrassing state, as I have had calls from my colleagues from all across the Caribbean who have looked at this news and have wondered what is going on with our system in Guyana. I want to say that we have to hold those persons who are functioning and who are operating in those investigative offices to very, very high expectations. And when these blunders are made, that they are called out on these blunders and they must correct them immediately. It is a clear, very clear indication that the persons who are involved are very ignorant of the law. Had they been knowledgeable of the law, they would have recognized that there are procedures and that there are provisions which are laid out in the law which will afford them some form of coverage to get any type of information that they want. But this type of forcing a person to make a statement and to make disclosures so that he or she can incriminate himself or herself is a very serious indictment which must be frowned on by all fronts. I want to say clearly that there is, and as we look around the Commonwealth Caribbean and even at our developed countries, dealing with financial matters and investigation requires certain very knowledgeable and prudent actions. And therefore, one cannot, it is an investigation of records. It is not an investigation of confession statements. And unless they are changing the entire method by which one can conduct such investigation, then we are in serious trouble in this country. Very serious trouble in this country. The nature of investigation being conducted at SOCU does not require a confession or a statement. It is an examination of records, and records can be found by the person, or it can be found wherever, at whichever industry or organization in which are subjects to the investigation. And therefore, at no front, absolutely with no excuse, can we support the action of the arrest of our colleague at bar. It is a very serious indictment, and I do hope that the relevant authorities will look into this matter without delay and will, of course, correct this type of behavior so that there can be a restoration of confidence in our judicial system. There can be some form of restoration of confidence in the police force, and that there can be some form of restoration among our citizens and our democracy. And I will say our judicial system because I am one who supports, without any reservation, that the judicial system, matters which go before the court, starts from the investigative stages. Fairness starts from the investigative stages. Fair trial and a fair hearing starts from the investigative stage. Because whatever you investigate and bring before the court is what the court must treat with. And if this type of behavior is allowed at an investigative stage and was not caught, one can only tell the high level of injustice that could have been meted out to a person who is placed before a court. Freedom of choice as it relates to one giving a statement is intact. A confession statement or a regular statement is not permitted or not allowed or not supported outside of the whole gamut of voluntariness. It is the pillar of the admissibility. Fairness and voluntariness. Without those, it cannot go anywhere, should not go anywhere with the court. And if it cannot go anywhere with the court, why would an investigator even attempt to pursue that? An investigator cannot say that they were unaware that a person has such a right to remain silent. Now, a person being arrested is given a caution. That caution, the very words of that caution, says, you are not obliged to say anything, but if you wish to do so, anything you say will be taken down in writing and given in evidence. What does this word mean? It means that they are aware that a person has that right to remain silent. There are no special laws which governs Soku. There is no law in Guyana which has suspended the caution, which allows the police to bypass the caution in any criminal matter. Soku investigates criminal matters. And criminal matters, there is law and procedure governing someone who is a suspect and is held in custody. A caution is administered after an allegation is put. It must mean that counsel's client had an allegation put to him, because you could not get to the stage of compelling a statement if an allegation was not put to you. So an allegation was put to counsel's client, which means immediately, instantaneously, it would have kicked in with the investigators that the very words of the caution, even if they were going to say that they were unaware of certain constitutional provisions which protects the person from making or incriminating him or herself, even if they were going to make that argument, the very words of the caution is there to remind them that you could not compel a statement out of a person and that the person has a right to remain silent. I want to say clearly, this action is inexcusable. So I want to close by saying that this incident today has caused us to move away from the regular type of discussion, and we wanted to bring this issue and to really say clearly that it is one in which we will not allow to go unchecked. I thank you until next time. Audio Jungle.